right. To maximize your video and audio quality during today's webinar, please either join through Google Chrome or the Adobe Connect desktop app. The chat box is located on the right side of your webinar window, and this is visible to all webinar participants and facilitators. You can use this to connect with other attendees, bring any technical difficulties to the speaker's attention for troubleshooting, or to provide any other comments and/or feedback. There's a dedicated question and answer box labeled Q&A, which is located right underneath the chat box. This is where you can submit any questions that you may have regarding the webinar content throughout today's session. Please do not submit any questions through the chat box. Please note that today's presenters will follow up directly following today's event with anyone who did not receive an answer to their questions. And this Q&A box is also not visible by anyone but yourself. So any questions that you do submit are only visible to you. Only the presenters can see all questions. And there will also be a copy of today's presentation available for download during the Q&A portion of the session next to the chat box. Please let me know in the chat if you are unable to download the file, and I will email it to you directly. If you're having any technical difficulties, again, please let us know through the chat box and we will do our best to troubleshoot. Today we will be joined by Andrew Svensson and Courtney Riviere, representatives from the SARM's Legal Services Department. Andrew is legal counsel for SARM, providing advice to SARM and its members on a variety of legal issues. He has been practicing law since 2008, initially in private practice in Weyburn, and joined the SARM team in 2011. Courtney obtained a law degree in 2019 and was called to the Saskatchewan Bar in 2020. She joined SARM's Legal Services Department in 2019, where she provides legal services with respect to claims under SARM's liability self-insurance plan and provides legal advice to RMs. Now, without further ado, I will now pass it over to Andrew and Courtney.
Thanks, Adam, and hello, everyone. It's really a pleasure to be with you in this webinar. My one regret, I would say, is that I don't get to kind of see you all sitting together, and I can't even look at you as I'm presenting. So I'd appreciate that you keep in mind that we're open to answering questions and not just waiting to the end of the presentation to field questions. We will hopefully give some time at the end for a question and answer sort of session, but use that Q&A box as we're going through the presentation, as your questions might arise that are applied to what we might be talking about, so we can kind of be more responsive as we go and not just wait till the end. There's two of us presenting, so while one's talking, the other can be watching that Q&A box, and we can field questions that way. Adam pointed out that Q&A box will keep you anonymous, so if you have any questions that you wanted to ask that you didn't want to be known for asking, that Q&A function facilitates that quite well. So Courtney and I are, let me just get my advanced function here, gonna cover some employment law principles, and these are arising out of common questions that we get in the legal department, and we're hoping that we can answer the most common ones through our presentation and provide you with information that's frequently asked of us. This kind of will follow the progression that's laid out on this slide. We'll get into the principles that give rise to cause for termination, specifically the process known as progressive discipline, and we'll touch on the idea of what reasonable notice is, and one of the things we wanted to cover was some employee obligations. Too often, all you hear about is the employer responsibilities, what you're obligated to do, but don't often get into those obligations of the employee. So we're going to cover a couple in some detail and balance that a little bit, and then just end with a few quick comments around layoffs and how you might go about that. Um, the focus in this is to help you as you try and create a positive work environment, and especially when you're dealing with problems caused by the performance of an employee. So just just to give some context, we're not going to focus on a setting where you actually have an employment contract, or that it would include kind of the union setting where there's a collective agreement. Uh, Typically, the principles that we'll talk about will find their way into a contract, either in the collective agreement or the employment contract. So if you operate with uh, an employment contract or in a union, then the principles we talk about likely are covered in that agreement. And if they're not, then you can consider the next time that agreement may come up for renewal to include some of these principles into those contracts. But strictly speaking, we're not covering those settings because the wording of those agreements will have an impact on some of the things that we'll talk about.
Yeah, so I wanted to just quickly touch on reasonable notice and what that might look like in this idea of employment and progressive discipline and everything like that. I don't want to spend too much time on this, but if there are any specific questions, like Andrew said, please feel free to put those in the chat or make note of them and add them to the Q&A. And we'll be happy to answer them. But just to give sort of a basic understanding of what reasonable notice might look like, essentially this comes from the idea that as an employer, you're not obligated to have an employee employed with you for forever. You do have a right to terminate them. When that termination is not for cause, though, you do have an obligation to provide reasonable notice of that employee's termination. So this principle comes from the Saskatchewan Employment Act, Section 260, and that provides this general idea that if you've had an employee with you for at least, or for more than, 13 consecutive weeks, then you have to provide some type of reasonable notice. And depending on how long they've been employed with you, that will affect what the statutory minimum notice is. So that little table that's included on the slide there gives you an idea of what those statutory minimums are. And it's important to understand that these are just the statutory minimums for notice. So if these are met, then the Labor Relations Board won't get involved. But there is still the possibility that if a former employee feels that he was wrongfully dismissed, then they could make a claim and seek damages for reasonable notice. So if that happens, courts often consider a number of factors when determining what a reasonable amount of notice would be, and that can include the employee's age, what type of work is available in the area, the employee's skill set, stuff like that. So there is case law to suggest that reasonable notice could be up to 1 month's notice for every year that they're employed. But again, like I said, it'll often just depend on those other factors that a court might consider in the circumstances. So oftentimes, if you're looking to terminate someone without cause and you're trying to figure out what reasonable notice might be expected in the circumstances, we often recommend seeking legal counsel and legal advice on that.
Yeah, so one question did come in, and I appreciate that, just asking about the need for notice during a probationary period. And most often a probationary period is for a period of like 3 months at the start of an agreement. Um, the the first question to ask in that scenario is whether there is a probationary period, and if there's not an actual written employment contract, then it may not be that there's a clearly understood probationary period. But if there is a probationary period, then that usually gives you the ability to test that employment relationship, and within that period, either continue with the employment or terminate that employment. Um, the case law is going to support the use of a probationary period if one exists. Um, and and another question came in about the notice period, including seasonal employees, and we'll talk a little bit more likely about that when we get into layoffs, kind of at the end of the presentation. But it would follow the similar principles of what the terms of the employment contract look like. If it's a seasonal employee, then it's typical that they'll be laid off. So if it's different than just the layoff, then the notice of that termination would also apply in a seasonal employee relationship. If that makes sense, Courtney, have anything
Yeah,
to add
no.
to those two?
I think you basically covered it. And yeah, like you said, we do go into layoffs at the end of the presentation here, and we do touch briefly on seasonal employees and reasonable notice and whether it applies or not. But yeah, I mean, I think I would just echo your thoughts on both those questions there. So
Okay, so if you're getting into the situation now where you're not giving notice of termination, but you want to deal with the problem employee, uh, maybe even considering termination of that employment relationship, but don't want to give notice or think you might have cause for termination, uh, the the presentation now shifts to that sort of context. And the principles of progressive discipline will guide how you answer and how you approach that decision as the employer. Um, and and it's more than just a discussion on the termination itself, but how to deal with the performance of your employees if you have problems with what's happening in the workforce. So we often get calls and administrators, and sometimes it'll be a counselor calling about an administrator, um, to ask how they deal with this employee that they aren't getting along with and are frustrated with. And so Courtney and I are going to kind of role play quickly what a common call looks like. I'll be the lawyer at SARM, and Courtney's going to call in. So, hello?
hi, this is Courtney calling from the RM of We Want to Fire Someone. And I'm calling because we have an employee that's been a problem with us for a while, and council is at the point of wanting to know whether we can fire them.
Okay, can you tell me what is going on with this employee that's causing the problems?
Well, he's not taking instructions very well, and he's been treating our counselors pretty poorly. Whenever they ask him to do things, he's not really listening. None of the other employees want to work with him anymore because of how he's treating everyone.
I understand. Has there been anything done to try and address this problem?
Well, council didn't want to offend him or make things worse, so we haven't really done anything. They just kind of hoped it would improve with time and being positive with him.
Okay, so I'm gonna hang up. That's kind of our little role play. If you've been in that situation or you feel like you're headed to that situation, then I'm glad you attended, because too often we get that call at the point where there's so much frustration with an employee that you just want to terminate that employment, but nothing's been done along the way. So to begin with, um, when you have concerns with an employee, keep in mind these simple principles. The, the earlier you act to address that problem behavior or the poor performance, the easier it is to deal with that. You need to be fair to the employee by clarifying what the expectations are so that they understand where they're not meeting those, and what they have to do in order to meet your expectations. You can help the employee improve their performance by providing direction to them. And finally, you can solve the problem before it gets to the point of dismissing that employee. And that's all part of the progressive discipline process. And and there's probably a significant amount of money invested in an employee to get them trained, to get them hired, that whole process. And so if you can improve the workforce that you have without having to dismiss and then go back through that process again, you're often better off by doing that. You know, certainly you'll get the employee that you just can't fix, but these simple principles need to apply in every situation where you're dealing with someone that you're struggling with.
Okay, so one of the first steps when you're dealing with an employee that's causing some issues is you want to identify what kind of problems they're exhibiting, as it'll have an effect on how you might want to respond to the problems or what sorts of actions you'll take in response. So you see, we kind of separated them into two different categories here. So issues of incompetence. Those are essentially where the employee doesn't have the skills or abilities to do the duties of their jobs to the employer's standards that they're holding. So sometimes when it's an issue of incompetence that you're dealing with, certain steps you might take would be to offer more training for them or provide more clear or more detailed instructions for them so that they understand what it is that's expected of them. Issues of misconduct, on the other hand, are where the employee's breaking the rules or policies that are in place or purposefully neglecting their duties, things like that, much more intentional in their actions. So we thought it might also be helpful to include this slide. It's a quote from Mr. Justice Wimmer in the Smith and General Recorders Limited case. It's essentially speaking to, it's a bit of a difficult quote to understand when looking at it for the first time, but essentially what he's saying here is there's oftentimes not just one thing or one action that an employee is taking that will justify terminating them for cause. Oftentimes there'll have to be either a pattern of misbehavior or, again, as we'll mention, these progressive discipline steps have been taken to reach the point of having justification essentially for terminating for just cause. So you might wonder then, when it is appropriate to terminate an employee for just cause. So we have a little list here of some general principles to keep in mind when considering whether you have just cause to terminate an employee or if you should be taking some additional steps before getting to that point or just terminating with reasonable notice. These principles might give you an idea of how to move forward in that sense. So important to note, and as we've said, dismissal for cause is an exception essentially to the rule. So you want to only use this as a last resort option really when dealing with a problem employee. So when considering whether to dismiss for just cause, you'll want to ensure that there's either been some serious misconduct or a substantial incompetence. And as an employer, you'll want to be able to demonstrate that terminating the employment was a proportionate action to take with respect to the behaviors that are being exhibited by the employee. So whether certain conduct will justify termination oftentimes will just depend on individual circumstances. So again, probably a good idea to seek legal advice if you're considering terminating an employee for cause. Things like dissatisfaction with an employee's performance most of the time won't be sufficient unless, again, you've taken those progressive discipline steps and it's been made clear that their job performance is not acceptable to the employer. As just a final point there, the just cause for termination is easier to prove when you have those progressive discipline steps that have been taken. Andrew will go into this in more detail in our presentation, but it just kind of shows that the employer has been taking steps to try to improve the employee's job performance and improve their behaviors, and it just has not been effective, and it's brought them to the point of having to terminate for cause. So this Socorro and RM of Lake Lenore kind of gives you a good idea of how these general principles have been applied by the courts in a case. So to give just a little bit of background on the facts of this case, it involved an employee that was a mower for the RM. He started in 2006, and then the RM terminated his employment for cause in July of 2017. So the employee ended up suing the RM for wrongful dismissal and was seeking damages for reasonable notice. And when looking to identify what types of problems they're dealing with, you'll see I've listed sort of some of the issues they were having with this employee. And in categorizing them, they can be categorized as misconduct. Those reasons that are cited by the RM for the termination are not with respect to any lack of skill or inability to perform certain duties. Rather, they speak to more intentional acts, like just not following instructions and refusing to follow policies, not mowing certain areas, even though he's specifically told to. Those are all exhibiting misconduct. So once you've kind of categorized those problems, the question then becomes whether they had terminated him for, whether it was justified to terminate him for cause or if other steps should have been taken. So the RM justified the termination of this employee, saying that they had all these problems, and when looking at them cumulatively, they were serious enough to justify the termination. They also discussed that they had meetings with this employee where his job performance was discussed and certain concerns were raised with him. And so he should have been aware that this was a possibility moving forward. The employee's perspective, on the other hand, was a bit different. So he talked to the court about how he had received raises over the years, and yes, he did discuss job performance with counsel at meetings at times, but so did other employees, and he never received any official warnings that his job was in jeopardy, essentially. So he said that these spoke to this kind of catching him by surprise, and he didn't really have an opportunity to address those concerns properly. It's also important to note that the RM in this case did have a progressive discipline policy, but it was not followed in this case. They just had all these problems and then went to the termination. So the court in the end agreed with the former employee that there was not just cause for terminating his employment. The justice in that case determined that the misconduct that was exhibited, even when looking at cumulatively, was not serious enough to justify termination when there were no other disciplinary steps taken beforehand. So that's why in most circumstances, the employer should be addressing employee behaviors, problem behaviors while they're still employed. So oftentimes those steps that you'll take will be in a discipline policy if you have one in place, or otherwise Andrew will be going into more detail about what that might look like and what steps you might be taking when dealing with these problems.
So there's often frustration on the side, your side, the employer, feeling like there's just so many steps we need to take. There's so many hoops that we need to jump through. And there was a question that came out in the box about this idea of so many hoops when there's an employee that just is unwilling to improve or change what they're doing, and how does the employer get to the point where they can just be like, this is enough, we need to get rid of this employee. And so Courtney explained that principle, that it's a high bar for just one instance of misconduct or incompetence to be seen as cause for termination. Those situations definitely exist, but it's a high bar for one event. So instead of relying on one event, you can rely on a series or a pattern that establishes cause for termination, but you can't be silent along the way when that behavior is occurring. You need to be able to say that you addressed that misconduct, that behavior, and gave some instruction on how to fix it, some warning on what was to happen, and that happened again and again. You addressed it, and the consequences increased, and then there was a warning that if that behavior continued, that it could lead to termination of that employment. So in order to rely on a series of misconduct, you have to engage with that employee and address those problems and concerns, and dictate what's expected, how to meet that in an attempt to try and fix it. And if it persists, then you definitely get to that point where you can say enough is enough and you're terminated, but that has to be clearly done through progressive discipline. So this slide really is important. And on the left-hand side there, that statement, I think, really needs to be understood. It's well established that where an employer relies on a series of inadequacies or inappropriate conduct, and then it gets into some of those things that would be one-off causes of termination, short of dishonesty. So dishonesty is one of those big things. So if you don't have that, and you want to rely on a series of inappropriate conduct for grounds for summarily dismissing the employer must have previously informed the employee of his or her inappropriate conduct or inadequate performance, and have warned the employee that she or he must correct the noted problems within a reasonable specified time or face dismissal. So that's the idea of progressive discipline. There's some elements listed in this slide, and we'll make the slide available to you at the end. There's also, we've also got a checklist that deals with if you're problems are incompetence or if they're misconduct, there's checklist that you can follow, and there's even this kind of flow chart that shows the steps that you need to take in either of those scenarios to establish a series of misconduct that or incompetence that you're relying on for cause for dismissal. And all of those things will be in this presentation, but there's also that case of Socorro that Courtney went through. That's a good good case to read because it's a good evaluation of this, and it's an RM case and one that is useful to read. And then this Government of Canada website has these progressive discipline principles also laid out, and the site is listed there. So hopefully that gives you a flavor to address kind of that frustration of how do we get to say enough is enough, and you're not making the call that we kind of showed as an example of a call we often get where nothing's been taken to address that behavior because you don't want to rock the boat or make that employee upset, or you thought it would go away without talking about it. You don't want to make that call. You want to be able to act early and address that behavior and be in a position when you're so frustrated that you can say, we can dismiss this employee. I'm just looking at the last question here, talking about putting things into writing, having it signed. That will clearly kind of establish that that step of the progressive discipline. So if you have something that you've wanted to address and you put it in writing and it's acknowledged by the employee, that goes on the file. Then if you have to prove that you took that step, then that's handy. So that's definitely helpful in your evidence of taking that step of progressive discipline. So great to see questions coming in, and appreciate the opportunity to answer those and focus our discussion. But that principle of progressive discipline needs to be really understood, because in most instances it's going to guide you in how you handle concerns with an employee. So now we're going to get into addressing some specific employee obligations, and I think often these aren't brought up, but important to cover. So we're going to talk about that.
Yeah, so like Andrew said, we kind of went through everything that's expected of an employer when dealing with a problem employee, but we thought it might be nice to just touch on some obligations of an employee and what's expected of an employee when they're working for the RM. So we put together just a little list here of those more essential employee obligations when they're employed. And just to kind of give a brief little summary of what's included on this slide here. It's expected of the employee to preserve confidential information respecting the employer. It's expected that they follow the orders of an employer where they're lawful, of course. It's expected that they have the required skills and competencies to do the work that's required of the job. There's a requirement that they show up to work and aren't absent for long periods of time without prior permission. And if they are on leave or ill, there may be requirements to provide medical information in that respect to show that the leave that's taken is reasonable. So we don't want to touch on all of these in too much detail, but we did pick out a couple that we just wanted to provide a bit more information, so there's some understanding of what you can expect from your employees when looking at these obligations. So I wanted to quickly just touch on this duty to report, as that goes into when employees are absent or chronically late, what kind of is expected of them and what measures can be taken in that respect. So it's fundamental to the employment relationship. It's at the root of the employment contract, as essentially it's an employer paying the employee for services. So it's expected that the employee shows up to provide those services to the employer. Failing to report to work can be costly to the employer, especially if this is happening time and time again. There might be replacement costs, there might be loss of production depending on what's happening, or other costs that may be applicable there. So there's a number of factors that can be considered when looking at an employee's either absenteeism or lateness. So the primary one that is looked at is this degree of absenteeism. So whether that could be justification for termination for cause. There's a quote from a case from a while back, Laws and London Chronicle, where the Lord Evershed says essentially the question must be, if summary dismissal is claimed to be justifiable, whether the conduct complained of is such as to show the servant have disregarded the essential conditions of the contract of service. So not showing up to work, I would say, is pretty essential to the employment contract and maybe justification for termination. So when looking at the degree of absenteeism, there's two main considerations you'll want to look at. The first being whether there was a reasonable excuse for the absence. So that could be something that's out of the employee's control, like an illness or a death in the family. That might be reasonable excuse for absenteeism. And the second being the length of the absence. So when determining whether that's a reasonable length of time, again, it's pretty intertwined with what the reason is for the absence. And you'll want to kind of look at those together to see what length of time would be reasonable given the circumstances. Again, oftentimes it's not going to be one single absence that would justify a termination, but those are just some things to consider there. You'll also want to consider whether there's been prior permission that's been provided for the absence that's been taken, and the onus is on the employee to prove that they had permission to take an absence or a leave from work in that respect. So generally speaking, the courts will provide an employee with more grace where the absence was a result of a misunderstanding, like maybe they received verbal permission to be on leave for a certain amount of time or take a vacation, but didn't actually get official approval for the leave. So if there's a misunderstanding like that, and there's a termination based off that absence, and if the employee were to sue, there is case law to suggest that courts may be more sympathetic towards the employee since they had this understanding that they thought that they had permission to go on this leave. Another thing that a court might consider if something like that were to happen is the employee's conduct and history with the employer. So if this has happened multiple times before the termination occurred, or if they've been a problem employee, those might be factors to consider when determining whether there was just cause for that termination. But again, hopefully in that case, you would have taken those progressive disciplinary steps, right, where they've been given warnings and things like that, that behavior is not acceptable. There's also some case law to suggest a pattern of lateness might be just cause for termination, although that's that would be a higher bar to prove there. Like lateness oftentimes won't be enough to justify termination for cause. It would have to be either linked with other problematic behaviors or be so late and occur so frequently that it would justify termination in that case. There is a case that I wanted to briefly touch on that kind of exemplifies all these factors that you are to consider. So it's Rowe and Western Printing and Publishing. It involved an editor who, he was the chief editor of this newspaper, essentially, and he was dismissed from his employment, and the employer listed that he was neglecting his duties and he was absent from work during their regular office hours, and he couldn't be contacted during regular office hours and was just rarely actually in the office during that time. So the employee was trying to justify these absences by saying that due to the size of the paper and the nature of his job and the duties that were expected of the job, he felt he had to fulfill many different roles, which required him to go to local events, so be away from the office and actually attend at the scene. And so he was often away and not able to be contacted because he's dealing with these other local stories that are not in the office. So the judge in that case found that the employee was wrongfully dismissed and there was not just cause for termination. He looked at things like he felt that the employee had pretty wide discretion with how to deal with his job and his duties. They weren't clearly laid out that he had to be in the office during these set hours. If he felt he needed to be away from the office to complete certain duties, then, and that was not communicated to the employee that he needed to be in the office during these hours, then they couldn't justify a termination for cause due to his absence in that case. It should also be noted that the employee had provided proof that he often went to the office at different hours. So he'd go late at night when nobody was there and do work that was required of him at that time. And then during the day would be away doing other duties of his job. So while he was absent from the actual workplace, he was still working on his roles as an employee. So again, it just speaks to the importance of having those disciplinary steps, providing those warnings, as it gives some clarification to the employee of what's expected of them, and hopefully will address those problem behaviors and then correct their performance essentially to how you expect it to be done.
Yeah, it Courtney, when you describe that, it kind of brings to mind that the opposite can sometimes happen as well, where the employee's present at work but actually not doing their duties or fulfilling their assignments, and maybe using work time to do personal things, and so again, if that's the situation, address that concern right away, and clearly communicate that that's not acceptable, and that they need to use the time where they're at work for work related duties, and that expectation is addressed, so that if that continues, you just progress down those steps. The other sort of comment I was thinking about that we haven't made is there's a principle in law called condonation, where if the behavior is happening over time and the RM isn't doing anything about it, courts can look at that and say, well, you were aware that it was happening and didn't do anything. So in some ways, you're communicating that behavior is okay, that you're not worried that they're doing it. And so you don't want to leave it and not address those things, because it could actually come and hurt you if you haven't addressed it earlier based on that sort of principle. Now, it's not a complete answer to a series of misconduct, but it makes it harder for you to establish that series of misconduct is cause for termination. I'm just watching the clock, and we're getting closer to the end of our time. We've answered some questions along the way, but I certainly want to leave time for questions to come. One additional one has come in asking if we have a template progressive discipline policy or related forms, and we haven't developed our own, and so the answer would be no at this point. It's potentially something that we could develop, but that would be, we would have to have that request come to the board or to Jay, and then receive that instruction. We have, however, helped review some of these policies and seen them in different agreements, and so we can help you if you're wanting to develop one for your RM. We can help you get into place, but it wouldn't be something that we could send out a precedent for at this point in time. And another question, I don't know, Courtney, if you want to read that and be prepared, I'll quickly address this duty of having to follow lawful orders, or sometimes it's seen as insubordination when people aren't following it. This is an important employee obligation that's often seen as the very essence of the employment relationship, what's bargained for. This idea that employees agree to do what their job description is in return for the payment of wages. The language is a lawful directions of the employer, so we need to understand that not everything that you're gonna tell an employee to do has to be followed, but it has to be a lawful direction, which kind of boils down to, and I have a slide that covers it, but it boils down to something that falls within their job description. It's not anything that they're told to do, but something that's within their job description. And so there's an obligation definitely on employees to follow those directions. And a common problem that we get is that there's employees that aren't listening to counsel as they give directions, and are refusing to follow directions, thinking they know better, even talking back, that sort of thing. So my slides go through some of the history, and in 1845, this was the language that disobedience of a lawful order of the master is good cause for discharge. You'll see in the history of these cases the use of words like master to describe the employer. This language begins to change, and it goes to say it's going too far that just one act would give rise to cause for termination, but it's got to be a complete disregard for the employment contract. You'll see a change that kind of tempers that all-out initial position, but still using words like servant, master servant, and order to describe it, and so we progress, and I'll quickly jump to today just for the sake of time, and in our conditions at the moment, there's a balancing of the need for the employer to give instructions, but not just one occurrence of a failure to follow those instructions giving rise to termination. There's a test in these cases that asks whether the misconduct of the employee was such as to interfere with and prejudice the safe and proper conduct of the business. So that's the current language of the test. but there's no actual fixed rule of law that defines that degree of misconduct. So it sort of leaves you again with this idea of determining, is there one event that gives cause for termination? That's a high bar. I'm usually going to have to take steps of progressive discipline. So there needs to be a series of misconduct that's been addressed progressively, and now I'm at the point of termination. So the direction that you're giving must be within the scope of the employment relationship. It must be a willful and deliberate act of disobeying that instruction. You need to know if there's any reasons for not following it. In one of the cases, there was an employee that had the flu, so was at work and did a number of things, but just got too sick to continue. The employer said, "You can't go home. Work's not done." They did, and they were fired as a result of that. But the court said, well, they had a reason that justified that disobedience. So there can be those reasons, and just noting that often it's not one event that will justify dismissal, but following progressive discipline. So that was a quick fly through of that topic. And then we'll just maybe conclude with some comments of layoffs, and then use whatever time we have for any more questions.
Mm-hmm. So we did have one quick question just with respect to what if an employee has done something and say it happened months ago, but the employer is just now finding out that the employee either displayed some type of problematic behavior, what you should do. I think it's depending on what the behavior was, you likely do want to address it with your employee and make sure that he's aware that that's not acceptable behavior. So again, you do want to follow those progressive discipline steps. I would think even if it did happen some time ago, you would want to have made sure that you've addressed it, just to at least ensure that it wouldn't happen again. I don't know if you have other thoughts on that, Andrew, but...
Well, I agree, and I think I would just add that it would be the point in time where you became aware of that, where you would want to address it, and just because there was some passage of time doesn't mean you can't now speak to it. Again, you might have some cases where that hasn't happened since, or it might be a case of, now that you know about it, you can see other instances of it along the way, and so that will kind of help, I think, identify what to do. But if there's behavior that you need to address, the only way that you can rely on that series of it is if you've done something about it when you became aware of it. Yeah.
Okay, so yeah, just looking at time, I'll go through this very quickly. So we just wanted to touch on layoffs. So layoffs, they're a temporary discharge from employment. It has to be for a period of time that's more than 6 days. So it might be for economic reasons. It could be just seasonal work, things like that. It could be an employee's job becoming redundant. But the two kind of notable considerations that I put here on this slide. So layoff is not just cause for dismissal. So there should be reasonable notice that is provided when somebody is laid off. The statutory minimum notice requirements are the same for layoffs versus termination, so there's no difference there with what would be expected statutorily. That's something to keep in mind, and I know it was brought up earlier in a question, is what if it's a seasonal employee or a term employee where they're expected to have this layoff come up. So oftentimes it will be addressed as part of their employment contract that when the season ends, their employment will come to an end and then they'll be recalled for the next season. So in those cases, you'll want to look at if there is an employment contract in place, what is expected. So if you're telling the employee that they're going to be recalled for the next season, or if it's understood that it's an indefinite employment contract, essentially, where there's just that period of time where they're not employed. If the RM then didn't recall that person for the following season, there could be argument for them to have been provided reasonable notice based off their entire employment with the RM. So I hope I'm making that clear. Like if a seasonal employee has been within an RM for, say, 10 years and was laid off at their normal time, but then when it came time for them to be rehired for the season and the RM did not, at that point, that employee could be entitled to reasonable notice or pay in lieu of notice, essentially, for those years of work that he has provided. So yeah, with that, I'll end the presentation and then we can hopefully address some questions if we have a couple minutes here.
And us off as needed. And like Adam said, if there are questions that you don't answer to, or if you have follow up on our way and hopefully these questions answered. So the next
Hey, Andrew, I think we lost your audio.
Okay, I'll try to answer a couple of these questions really quickly here, and hopefully Andrew can get his audio figured out. So let's just see here. So does an employer have to recall a seasonal employee the following year? If we decide not to, do we have to tell them in the fall? Yeah, oftentimes if you know ahead of time that you're not planning on recalling the employee, it's a good idea to let them know. At the very least, you wouldn't want to be giving them the impression that they would be rehired for the following season. So you don't want to be saying to them anything that would give them the impression that they would be rehired. And again, depending on the type of employment contract you have in place or the understanding that you have, if they've been consistently recalled year after year, they might be entitled to that reasonable notice at that point if you are not recalling them for the following season. Don't know, Andrew, if you're back, if you want to test your audio or if you're still figuring that out.
Can you hear me now?
Well, I can. Yeah.
Does it work? All right, good.
Yep, you're good.
So I'm not sure where I cut out, but I was just addressing the question of how counselors fit in. And they would be considered the employer, but depending on the specific management structure of your individual RMs, the involvement or the role that counselors play may look a little different. I'd focus also your attention on Section 111 of the Municipalities Act that talks about the role of the administrator. So in employee situations that don't deal with the administrator, then typically I think it's subsection 3 that talks about the role of the administrator to do the hiring, to do the communicating of any sort of discipline or termination of that employment. So often the administrator will be the one to be doing these things with the employee, unless your RM has made a policy that's different than that. Then typically that'll fall to the RM's administrator, unless I suppose it's the RM's administrator that's the employee that needs to be addressed and in dealt with.
Yeah, so we had a question here. If the court's decisions are in favor of the employee, is the outcome typically that the employer has to pay a severance? So normally when it's going to court, the employee is suing for wrongful termination and seeking damages for reasonable notice. So in those cases, if the court is siding with the employee and rules in their favor, it often will be like a pay in lieu of reasonable notice that they're getting essentially. So again, looking to those factors of their age, their skill set, what kind of jobs are available to them in the area, those will all play factors into what might be considered a reasonable notice. But yeah, oftentimes it'll be essentially what their salary was at the time of their termination, and then applying that to what a reasonable notice would be.
Yeah, and hopefully you don't get the idea that courts always side with the employee. We've cited some examples of that, but if you've taken the steps that we've outlined and have cause for termination, then you can sever that relationship with confidence. It may be that those cases never get to the courts because there's no point in the employee making that challenge because you've done the right things along the way. So there's not a case that has to be decided about that. And the other thing is that often things can be settled along the way. And so if there's been a claim made, there may be a settlement along the way that favors the employer. So don't think you have no ability to control your destiny here, or just pay severance in every situation, because it's not as imbalanced as you might get the impression from some of our comments. There's lots of good questions here, and I don't know if we've answered them all in order, but there's a question about how long you leave something in an employee's file that's been a step in the discipline process, and there's no fixed amount of time where something drops off. But if you've taken a step and the problem hasn't reoccurred following that step for a period of time, you're going to get to the point where you almost need to start over again if that behavior arises. And certainly, if it's a year in between, I think you can be confident that you can't say it's a series of events. You'd want to kind of come back to the start. But if you're wondering about whether there's been too much time pass from the one event to the next, just give us a call or talk to a local lawyer that you use and have that discussion at that time. But certainly the amount of time in between behavior can have an impact on that employee and what you do.
Yeah, we had a question. If you lay off an employee in the fall, do you have to rehire them in the spring? There's no obligation to rehire as long as they understand that they're a seasonal employee. Again, it'll depend on the specific circumstances of that employee and whether it's expected that they get recalled as to whether you'd be required to give them a reasonable notice. So if they've been recalled year after year, or if there's an employment contract in place, that might have an effect on what a reasonable notice might be if you don't plan to recall them in the following season. But as far as I'm aware, there's no obligation to have to recall an employee that's seasonal.
But it's good to have it clearly communicated, whether this is a layoff or a termination of the employment. So if there's an expectation of rehiring, then I would say give that notice, that they're not going to be hired as soon as you can, to give as much time in that layoff period for you to satisfy any notice requirements. That was kind of some of the other questions that followed were similar.
I don't know.
Yeah, so some last questions were a specific example of what to do, and if you want to just give either Courtney or I a call or an email after this, we can answer some more very specific questions about an individual employee and what they're doing or what they're alleging is happening. So feel free to do that. Thanks for all the questions. I hope we've been able to understand them and answer them as they've come.
Yeah, it was nice having the questions throughout, so I'm glad we got some engagement here. It's always nice to know that we're getting through. So I'm happy y'all had questions for us.
Thanks, Andrew and Courtney. We appreciate you guys taking the time to present to our members today. And to everyone else, have a great day. We are actually, before we go, we will be following up directly offline with any questions that we did not answer throughout this session. So please look out for that. And if we do not get back to you, feel free to contact Andrew and Courtney directly. And also the presentation is available for download. And you can also send me an email at coordinator@sarm.ca to request it. So with saying that, have a great day, everyone.
Thanks again.